Ma'am, you are charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On December 13th, 2025, Officer in Harris County dispatched a disturbance call at the West Houston Hospital. The complaining witness, a registered nurse caring for the defendant, advised that the defendant was walking the halls gathering hand sanitizer from dispensers and throwing it at the complaining witness, hitting her in the face and eyes and causing pain when it got in her eyes. Defendant then threw water on the complainant, striking her in the back of the head. The complainant advised that she felt pain as well.
So where was this?
Hospital, West Houston Hospital.
Okay. Ms. Alice, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to go back to this hospital. If you do, I will revoke your bond and put you in jail. No more PR bonds. Do you understand, ma'am? This is not a revolving door. If you pick up a new case, if you put hands on anyone else, I will revoke your bond, put you in jail, and I'm going to make your bond high. Do you have the ability to hire a lawyer? Deputy Edgegon will give you an application. I will have bond conditions created for you to sign. Do not leave until you sign these conditions, and then we'll find you a lawyer here momentarily. Please. So no contact me.
Yes, sir.
All right, Judge, next is page 6, Brown, come on up.
All right, you are Miss Brown. Ma'am, you are charged with assault, bodily injury. You're facing, thank you. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you cannot afford a lawyer will be appointed to represent you. Okay.
On March 11th, 2026, Officer in Harris County dispatched a family disturbance call. Complaining witness on scene advised that he and the defendant live at the address, and they were arguing that day, and the defendant locked herself in her room. The complainant went inside, and the defendant started throwing items at him, pushed him to the ground, falling on his left leg, causing pain, and struck him about 4 times on the body with her hands, causing pain. Complaining witness also showed officer the recording of the incident.
Who was it?
They live at the same address, Your Honor. The didn't don't say that they are in a dating relationship or anything like that.
Okay, Ms. Brown, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with this person. You're also ordered not to be in possession of any weapons. You violate these conditions, I will order your arrest, put you in jail. No more PR bonds. Do you understand, ma'am? You have the ability to hire a lawyer. How do you support yourself, ma'am?
I'm working.
Okay.
I just don't have extra.
What do you do for a living?
I'm a kid.
Okay, and how much money do you make a month?
That's $2,000.
Okay, Deputy Etchegorn can give you an application. I need to know everything about you, how much money you have coming in, other sources of income, you have a car, and then I'll take a look to see whether you qualify. Money in the bank, I need to know everything about you. Come on, just no contact, no weapons.
Sign for your picture. All right, Judge, bottom of 26, Pollard, come on up.
What page was this?
Bottom of 26.
Thank you. Sir, you are charged with harassing communication. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On September 12, 2023, a complainant walked into the police station and explained to an officer that she had been receiving text messages and voicemails from her ex-boyfriend, defendant, after they had broken up. They dated from 2017 to 2022, and defendant continued to send her messages through various means even after complainant had repeatedly told defendant to stop contacting her. Defendant continued to message her and left a voicemail on September 10th, 2023, sent a message on September 11th, 2023, and on September 12th, 2023. Defendant had stated that he knew where complainant lived, he could appear anytime, and also stated he did not care if she filed harassing charges. Complainant does not feel safe and asked for charges to be filed.
Got it. All right, Mr. Pollard, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with this person whatsoever through use of social media, text messages, phone calls, anything. If I find that you do, I will revoke your bond and put you in jail. You understand? Do you mind reaching out to the complaining witness to let them know about the conditions? And then you can also do a RIF, and then we'll go from there. Please, we are going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. After that, I'm going to have you take a seat while we get your bond conditions. Once you sign them at that point, please free to go.
Yes, sir.
All right,
There's
Judge,
no contact.
No contact, no weapons.
council's approaching for top of 28, Sandoval.
Morning, Ernie. Morning. Happy Wednesday.
Yes, conflict.
All right, good morning, sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 11th, 2026, in Harris County, Texas, officer was dispatched in reference to a motor vehicle accident at the intersection of Jones Road and Fallbrook Drive. Defendant appeared to be in a confrontation with the other parties on the scene. Upon initial contact with defendant, officer could smell a strong odor of alcoholic beverage emanating from defendant's breath and or person and observed him to be unsteady on his feet. Witness stated she stopped at a red light and defendant's vehicle struck her vehicle in the rear. Witness observed defendant to be the driver of the vehicle, and defendant also made statements about operating the vehicle. Defendant declined standard field sobriety test. DIC was read and defendant refused to provide a sample. Officer observed in plain view a defendant's vehicle, a beat box alcoholic beverage with a small amount of liquid inside, and an empty twisted tea can and an empty buzzball container in the passenger side floorboard. A blood search warrant was signed and executed.
All right, address probable cause to the arrest, Judge.
Sure.
Judge, the officer does not state any reasons or any facts showing that he had lost his mental or physical faculties. Just smelling like alcohol is not just a statement that he smelled like alcohol. It does not go to mental or physical faculties. He didn't perform any field sobriety tests. He didn't talk about red bloodshot eyes or slurred speech, all the typical indicators of loss of mental faculties contained in that probable cause.
He's got alcohol in the car and there's an accident though.
I mean, that doesn't go to loss of mental or physical either. That goes to potentially having alcohol in your car. I mean, that's a traffic ticket for that or,
No, but the accident.
yes, but that's an accident. Doesn't go to mental or physical.
Your Honor, he smelled the strong odor of alcoholic beverage. He smelled the strong odor of the alcoholic beverage on defendant's breath.
Are there any other
And
indicators?
he observed defendant to be unsteady on his feet.
What, I mean, that's just a conclusionary statement.
I mean, I think that there's enough for probable cause. Mr. Sandoval, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, I'm now ordering you not to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you drive a vehicle that doesn't have an interlock, it doesn't have one, I will put you in jail and I will make your bond high. Do you understand? I'm sending notice to DPS in Austin so that every police officer in this state knows if they catch you driving a vehicle, that vehicle doesn't have an interlock, they're going to take you to jail. You understand? Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Martinez. If he tells me he cannot get a hold of you because you're ducking and dodging, I will issue a warrant for your arrest. Do not pick up any new cases. Do not use anything illegal, including marijuana. Do you understand? You will get tested. For now, I will have you go to Victoria Center Reset. You'll get with Veronica with your bond conditions, and after that, you're free to go.
I know the judge is your policy, but for Mr. Sandoval, is it agency parole for the interlock?
Always.
Yes, I just want that
Sure.
to figure that.
Yep.
Thank you.
Okay, can you file the guardian in one?
It's in there.
Good. Okay, great.
Right this way. All right, Judge.
Hold on. I have a lawyer here. Bear with me. Let me see. Well, Todd, do you have an arraignment?
No, Judge, we've already appeared in court. We have our ALR set for the 22nd of April. It's on Tennille Matthews. You already waived her appearance and bond conditions already in place, and so I was just looking for a reset.
Page 20. Can I just have a reset a little bit? Top of 20.
How about 20?
Yeah,
How is April 21 through the 23rd?
Her ALR is on the 22nd. Let's do that same day. That way I can let y'all know how it went. I'll just be running a little bit
you don't
behind,
want
but I
the
gotta
day
be there anyway.
after, Todd?
No, that works fine. I can just do it early in the morning, and then just come there and let everyone know how it went and we can keep moving forward.
You can always zoom in here too, and it'll still be waived for your client as well.
Okay, perfect. Let's do the same day, April 22nd, if that works for y'all.
Okay, man, you got it.
I appreciate y'all. Have a great week.
Have fun.
Thank you.
Full access to a vehicle. Then we have all
He's gonna sign an affidavit not to drive. You're signing a promise with me, an affidavit that you're not gonna drive. You're not allowed to drive. Don't get tempted. Do you understand?
Just ready for the next one?
Please.
Please sign the
Top of 27, raw.
Morning, sir. Sir, you're charged with discharging a firearm in a metropolitan area. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 10th, 2026, in Harris County, Texas, officer was dispatched in reference to a report of multiple gunshots in the area. Officer met with the community members who stated that there was usually a group of individuals who think outside drinking alcohol and occasionally shoot guns into the air. The community members pointed officers in the direction of a property, and officer observed 4 males with alcohol beverages in their hands on the driveway. Officer observed multiple spent shell casings near where defendant was previously standing. Officer detained defendant and observed the end of an unholstered semi-automatic handgun protruding from the pocket of his shorts.
How do you know he fired it?
There was shell casings near where he was previously standing.
There was 4 people.
But the shell casings were where he was previously standing.
So? We don't operate on hunches, right? This is the law. It's either, black or white. Not gray. Unless you have something more.
I'm taking a look at the dims right now, Your Honor. This is straight from the dims. Straight from the dims, Your Honor, based on the reports of gunfire, the proximity of the spent shell casings to where the defendant was standing. And
The officer could have done one more thing and made one more question, but no. I'm going to find no probable cause in your case. Please, sir. Okay. Hey, Mr. Bailiff, talk to me.
I'm here on Mr. Vish Patel. Your Honor, it's more than 180 days, so I'm approaching to talking about this case. My client's from DWI. He's got 2 priors out of Missouri. He was going to refile his DWI Thursday, what I understand.
We are good. We've contacted her to refile it as well.
When?
She should be coming out today.
Okay, so he's got an interlock.
Yes, sir. Yeah, yes, sir. You
Got it.
already caught that way before.
Okay, so do you know when?
It should be done today. We were talking about it yesterday, so.
Got it. All right, let's set it a week.
Yes, sir.
Okay. Got
Would
it.
you like him present in the week? 186 days.
I mean, I'm gonna start, we gotta do something. If you guys don't get it indicted, then,
And we're willing to negotiate on that. I think they want to.
Sure, yeah,
Thank you.
okay, all right. I'll waive it.
Yes, sir. And
If it's not done, I'm giving you a week after that and we're gonna go forward.
Yes, sir.
So,
Thank you.
all right. Hey, what's up?
Morning, Judge. How are you?
Talk to me. What's up?
Mr. Ballany came back negative for his drug test.
Okay, great. So we'll just give you a setting.
Okay.
Okay,
Moving forward, can he do the Quest diagnostics? Can we
sure,
Change that.
but he'll have to pay for it.
Understood.
Yeah, I'm okay with that. Yeah, just let Veronica know so we can make that
Sure.
bond
Thank you,
modification
Judge.
for sure.
Judge, we have an upcoming plea.
Okay. Hi, Pete.
Morning, Judge.
What's new, man?
I to open notice on notice.
Okay.
Judge, you agreed to do the plea if you paid restitution. I paid the restitution yesterday, so.
We have received this, sir.
Mr. Hernandez, if someone has something of yours, your prized possession, like a TV, a car, a house, and they break it, you would want to be paid so that you could be made whole again. That's all what we want here. You were pleading guilty to this DWI. It is now going on your record. And you will be now facing a minimum of 90 days in jail. Do you understand? What we're doing today, it's now a minimum of 90 days. Do you understand? Every time you get pulled over, officers will see that you have a prior DWI. If you smell like alcohol, what do you think they're going to do? Right. So if I were you, from now on, I would never get into a car and drive, even if you've had a sip of alcohol. Do you understand? The agreement that you have worked out is 6 days in jail with credit for the 2 days that you have done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, this will stay like this forever. Is this what you want to do? How do you plead to the offense, guilty or not guilty? I'm going to find you guilty. I'm going to follow this agreement, sentence you to it. Good luck. Good luck to you, sir. I have to suspend your license. I will do it for the minimum, which is 90 days.
Jeff, can I address the DPS fine on this?
Is it a true first?
Let me check, Judge.
If it's a true first, I always waive it.
It is.
Then I'll waive it. But on seconds, I'm going to have a problem.
Understand.
So,
I was a little excited for some evidence on it. Keep my mouth shut and move on.
great to see you. All right. Good luck, sir.
I've seen how people you can share in actually.
All right, Judge, problem 49, Stewart,
Yeah.
That's why.
the application has been completed yet.
Where's Mr. Stewart?
He's not here, so we.
Okay, so let's give him a week. He's got to be here.
Okay, I'll get it down if you tell me what you want to do.
He's got to file the thing though.
Yeah.
Please. A week? Is a week okay?
I'll make it okay.
Okay. Okay. Oh, hold on, Cheryl. Hey, guys, on Stewart, DWI, does he need a mitigation packet? Please? I don't know anything about the case, so I don't know if there's an accident or.
No accident, it's below, 0.15 and no.
So approved?
So, yeah, it should be.
Okay, great. All you need to do is the application, get the insurance, and that's it.
Very good.
Yeah, he's approved?
He should be 40 approved though.
He can't be approved until the application is in it.
Okay, so all you gotta do is submit the application. Okay, yeah, okay, yeah, 1 week, 1 week, yeah.
All right, got it.
We approve.
Hey, what's up, buddy?
How you doing?
Happy Wednesday.
You want to say?
What you got?
Also, I'm not going to judge, I'm Jay Anderson, I'm not going to.
Henderson is his last name?
Yes.
You say I'm probably gonna be mad?
Right.
I'm not gonna be mad, but if it's old, we gotta have to, we can't just keep it open forever.
Page 3.
Oh, page 3. Unless you picked up a new case.
No.
Okay,
So this one was literally by PTI. Everything has been sent in. She has her advice, DAP, all that's sent in. The issue apparently is that, the DWI PTI person for this court is saying that there was some document that we need to also have showing the advice and the vendor agreement. We sent over the receipt, and proof that she has the device. My client is saying she never received anything else. So we're trying to figure out what document is that he's wanting.
so let's roll it till tomorrow.
Thank you.
Yeah, I'm gonna roll this day for day. It's 276 days. I'm not gonna just do long resets anymore, day for day. It's just too old. I mean, really. Oh, she's not even here.
So,
She's supposed to be here.
and then she did, so essentially the reason that she's not here is because we thought that we had everything done and that the original.
But there's always something else that never gets done, or we're missing this, and now we're at 300 days, and I get it that she's a traveling nurse, but at some point, we gotta, you have to comply with court orders, right? You're told to be here unless everything's done, it's not done.
But I didn't want to be clear, Judge, that wasn't my fault, because I prematurely told her that she was good, everything was done.
So let's do this. I'll give you till the end of docket today, reach out to your client, get what she needs to get done, try to get it to them, and hopefully she can get it today, until like 3 o'clock, I'll give you to get everything done to you. They can file the supervision order after docket. I'll sign it but I can't, we're now at 276 days. I've gone above and beyond to give extra, just because she's a traveling nurse. And here we are, 200, it's still not done. Okay, so reach out to her. She needs to get to the vendor, get whatever needs to get done. You've got till 3 o'clock. Otherwise, I'm gonna roll till tomorrow, or no, I have to issue a warrant. She's not even here.
We'll get it done today.
Okay, all right, please. Okay.
Maybe question?
Yes,
Bill as a center on the docket.
what was the last name again?
The center, DEC.
Got it. All right, good morning, Ms. Zacena.
Good morning.
Ma'am, you were charged with driving while intoxicated. Is this a true first?
Yes, Judge.
You have worked out an agreement where they are offering you a 180-day jail sentence. However, it appears that we are going to probate this for 1 year. You need to understand, Ms. Zacena, that this will still reflect as a conviction on your record, and it will be there forever. Every time you get pulled over, officers will see this. If they smell alcohol, illegal drugs, it's probably not going to go very well for you. From now on, after today, it is a minimum of 30 days in jail. There are no more proverbial slaps on the wrist. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you can never change this or undo this. You understand? Is this what you want to do? How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to follow this agreement. I'm going to sentence you to probation for 1 year. To complete this successfully, you must do a DWI education class. You must do 1 victim impact panel. You must also do a TRAS. This is an evaluation to see what other conditions you need. If they assess other conditions, you must fulfill them. A guardian interlock, no alcohol, drugs, random testing, and 20 hours of community service. There is also one more thing, no breath test refusal. If you were pulled over, an officer asks you to submit a breath test while you are on this probation, you must do it.
Judge, sorry, I should have spoken up. I've admonished her not to drive. She does not have a license. I've also, so if we may need to change, we need to make it a mobile device if we may.
Okay? You will be signing an affidavit with me today promising me you're not going to drive. Ms. Encena, I hope above all else, you do not drive. There's nothing in this life that you can justify doing it. If you drive or if you violate any of these conditions, I will issue a warrant for your arrest. I will have a hearing to determine if you violated this agreement. If you do, you are looking at an entire year. Is it 180 or? You were looking at 180 days in jail. Do you understand?
Yes.
All right. All right. Good luck to you. Thanks. Yes, sir.
Thank you.
Sean, can you talk about Jason?
And I had already told him to start up bounce off and there was still. So I just wanted to address him.
Who is it? Confiscate the phone, delete it, and then let them, banish them out of the court and let them know if they ever come back, I'm gonna hold them in contempt. But delete everything. Mr. Vela, I would strongly advise your client's daughters, if they ever try to videotape again, I'm gonna hold them in contempt and I'm gonna throw them in jail. She told them not to and they did it anyways. Tell them to get out. Out. Hey, keep it for now. But make sure everything's deleted though, please.
Okay.
Jason,
Yes, Judge, how you doing?
what's up, buddy? How are you?
I'm good, I'm good. Judge, there is a lady up there by the name of Faith Hernandez I'm subbing in on. I just haven't filed the motion.
What's the last name?
Hernandez.
Just the last name, Jason.
Hernandez, Judge.
Top of 15. It's on the sub on, it's one that you.
The case is old, Jason. Are you subbing in?
I am.
Okay, have you filed a motion?
No, this is pretty fresh. I was gonna get a motion in over today, but I see she's on the docket. So Judge, if you want to roll it to next week, I'm fine with that.
Today's plea or trial, Jason. It's
It
200
is.
days old.
I mean, she doesn't want to plead, so I mean, I understand.
When are you gonna file your motion?
I'll file it today, Judge. I can get a motion in. I can't get it in right now, but I can get it in this afternoon.
I can't do anything with the case until you're signed on, so I have to wait for the lawyer to get here.
I'll
Because when you sign on and I grant it, then you can take over and do what you want, but until that point, I gotta wait for Dane to get here to do what he's gonna do.
That's fine. What I'll do is, Judge, I'll have somebody file it for me. I'll get somebody in my office to file it.
Okay?
All right. And
You want me to
I'll,
roll it till tomorrow?
yeah, if you can.
Sure?
Okay. I'll get
Okay.
that done, Judge. Thanks.
All right.
Yeah, I will.
So there's a couple of Hernandez was the first three of the cause number, but there was like 4 Hernandez on docket.
Oh, 258-1300.
Okay, perfect. Thank you.
Sure.
Miss Alice? Yes.
Hey,
Good morning.
what's up, buddy?
I have no, I'm being told to approach, Juan Padilla, Jose Padilla. We reset it, to this date because we were waiting, for the breath discovery. And the ADA has not received it, so
It's
not coming in, great, all right.
200 days, man. We don't have discovery yet?
once.
I mean, talk with them, make sure that they don't have something now, but I'm not waiting any longer.
So I understood, so I,
Just delay it, as they say. All right.
Judge. So they didn't release something today. I haven't seen it. And I have a very short.
What did you release?
Okay. So I just, the breath test, instrument history certification.
Okay, can you want to do it tomorrow? Well, just to see if you're happy with what you got.
Right, one thing, can I have like next week?
Okay, if you want, I was gonna give you, but okay, if you want it. Okay,
Make sure I have. That's.
that's okay.
All right,
Abel,
well,
you're okay.
I'm not asking too much. And we'll work it out fine.
And what?
We'll share it.
Whatever. You're good, man. Don't worry about it.
Not terribly.
200 days is old. When you have every damn case, it starts getting 200, then they start digging this, and then then you get to 250, then you get to 275.
You know I don't.
No, I know. I trust you. Don't worry about it. Brock,
Morning, Your Honor.
you got a case with us today?
I do. I got Miss Amy Comperet.
Is that with a C?
Yes, sir. With a C.
Okay, you're at 150 days. Where are we going?
Yes, Your Honor. So the state has offered her time served. I need to see if this is one that they would automatically approve for PTI, being that there was a single car accident, or if this is one I need to do a mitigation packet.
If there's an accident, it's gonna need mitigation, dude.
That's what I figured. So I've already told my client to start preparing that packet.
Okay, so here's the
preparing
deal.
information.
You're now at 150 days, so I'll give you about 2 to 3 weeks. At that point, she's got to have everything done and turned in, otherwise we go forward.
Yes, sir.
Because by then you're gonna be late. You're gonna be at
Not a problem,
180,
Your Honor.
okay?
Yes, sir.
And then after that, no more waived appearances. Give me a
Yes,
second,
Your
I'll
Honor.
get your date.
Judge, 3 weeks brings you out to April 7th through the 9th.
April 7th through the 9th.
Okay. I can do, let's see. I can do the 9th.
Okay, it's yours.
Required of him?
Yes. Packet must be turned in or we move on.
Okay.
Okay. Bye bye.
Thanks so much,
Bye,
Your Honor.
Brock.
Have a good day.
You do. Take care.
Now, first, Judge.
Tell me.
Good morning, Judge.
Hey, what's up?
I'm here with Ms. Wall. She's on docket today.
Yes.
She's charged with criminal mischief. We have a non-violation report that we want to do against the court.
Okay.
Ms. Wallace currently has an interlock device, a portable device, where she blows into 3 times a day. She has never blown alcohol into her device because
She don't blow into it. That's why.
well, it's only been about 7 skips in the last 90 days. The reason why she's had those few skips is because she has her kids and sometimes she's dropping them off to school during that period or picking them up. She also works for H&R Block, so she's really busy. So sometimes she has to step away from her desk to go and blow. When she blows outside of the window, because I received the records, sometimes she blows just outside the window, but it still counts as a skip. So even if it's 2 minutes outside the window, it's still considered a skip. So some of those records show that she was blowing outside the window, negative, but it was still counted as a skip.
Yes, Judge, so we have 7 skip tests, but 6 were outside the window.
Did she blow? On those 6, did she blow after?
On those 6, she just goes outside the window. I don't have a specific time of how long it was outside the window. I'm still getting the reports.
So here, I mean, I'm gonna put a monitor on her then, because I can't trust her to do it, you know?
Another question I wanted to bring up there is that she goes to a meeting 3 times a week. Since this, she provided documentation of that.
I'm not taking it off.
Okay.
I'm not taking it off. She's got violations, so I'm considering putting her in jail, right? It doesn't get better when you have violations, it get worse. Miss Wall, come up.
There's another question that I want to bring up, Judge, that in this situation, Judge, was more, it wasn't no proof that she was intoxicated in this situation, it's just the word of the plain witness. You know, they're going through a custody battle, or they were going through a custody battle at the time. Now they're joint custody, so he's just throwing hard evidence wall, basically trying to make her appear to be something that she's not. The judge in the family court gave her joint custody with him. He tried to use alcohol as a condition to get custody, but that didn't work. So that's.
Then you got to be smarter, because you know, in this life, there are how many vindictive people. They're going to use any and all means. This is something that you have at your disposal that you can use to prove he's not true. And here's the proof. You know what I mean? So it could really come to your benefit. The problem is you're skipping now. I'm going to continue, but it's no tolerance going forth. If there's another skip, it's really not going to go well for you. A second violation is not going to go well. You understand? Keep it up. After a while, if we're still okay, then I'll consider it. But at this point, she's skipping and I'm not happy. I'm not going to take it off and reward you for skipping tests. But I'm telling you from now on, it's no tolerance. Do you understand? Okay.
We'll come back in like 30.
I don't want to commit to a set time, but just you guys talk,
All right.
but I don't want to commit to a set time, but when we feel comfortable that at that point,
All right.
you know,
All right,
All
we'll
right.
talk about that. Thank you,
Okay.
Judge.
all right.
It's just a continuous supervision.
Continue supervision now, same conditions now, but now it's no tolerance. Any more skips? That's it. Hey,
I have Lewis.
Okay.
The jail doctor.
okay,
Judge, we're one for on bond. So this is a case, this was a 2B from December for an offense in October. During that time, she hasn't picked anything up, Judge, so, she's indigent, but when I talk to her, she has a place to stay. She's giving me a good number, so we'll be asking for a PR bond in this case.
it's a first time? They didn't give her a PR bond?
First time, this is her first time through.
She's
so
no-
not like she's
no
yet started or
FTAs.
anything like that.
Huh, okay, yeah, I'll give you a PR bond. But, let her know it's not a revolving door. And then she's also has to sign conditions, no contact with the complaining witness and no weapons. And then, yeah, I'll grant you a PR bond, but tell her this is it. You don't get another one. If you fail to appear, it's on you. All right? Okay, man. Have fun. Yeah,
I've got beyond the dentist.
okay.
Case is just getting a little old, so I need to go for a reset. You can, they've offered some deferred. Could we do his next hearing for required and give him 2 weeks? It's at
Yeah,
It's 175 days.
I mean, I'll give you a week,
Okay. A week
but
to come in.
yeah,
He's
I mean, we've
making
given
some-
you already a month to consider the offers.
Yes,
You
you
said
did.
since the beginning of or mid-February. We're now,
Yeah.
mid-March. So I'll give you a week. He's got to come here in a week.
1 week.
Yeah, 1
here's
week.
required.
Yep.
Okay, thank you, Judge.
How long time is it?
Hey, little list, please.
Yes, Judge, we have two of them. Yeah.
What time did they get here?
Then doctor at 11, age 26.
Come up, Mr. Pena. Court starts at 8:30, not 11, not 12. Barwa, can I borrow you for a second, please? Sir, you're charged with falsifying drug test results. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
This is just your opinion.
Yep.
On March 11th, 2026, in Harris County, Texas, officer conducted a traffic stop on a vehicle with an expired registration. Officers ran defendant and found he had warrants, no driver's license, and no proof of financial responsibility, and an expired registration while operating a motor vehicle. Officers conducted a search and found 2 small bottles of fake urine inside of a Ziploc bag in the driver's side door. Officers also found a signed notice of special conditions from the state of Texas Parole Division. Officer asked defendant what he was doing with the bottles of urine, and defendant responded, "I'm trying to pass a drug test for a job." Defendant stated he was on parole.
Sir, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs, and I'm going to test you like crazy weekly to make sure that you're not using. If you do, I will put you in jail. You understand? There will be no more PR bonds for you. Chances are, you picking up cases, you may very well get a blue one. Do you understand? Do you have the ability to hire a lawyer? What do you do for a living?
I'm looking for it.
Okay. Can you go ahead and just appoint him a lawyer? So Veronica, no weapons, no driving. You're going to sign a promise with me today, Mr. Pena, that you're not going to drive. I don't give a rat's behind what you have to do in this life. You don't have a license. You don't have insurance. Do not drive. Do you understand? So tested weekly, randomly. I'm going to have you sign a reset. We'll have you sit with, sign your condition with Veronica, and then I'm going to have you take your seat in the jury box. Go ahead. Vic, who's the next one?
Next one, Judge, is page 2, Ali. It's by, I think, All right, what happened? She was she started acting from preventing drug testing.
Say it again.
Mr. Ali was given conditions by, magistrate for random drug testing.
Okay.
And no contact as well as the travel restrictions and no firearms and weapons.
Just conditions stay. Yeah. All right, you are Mr. Major. Sir, you're charged with criminal trespass ×2. You're facing up to a year on one and up to 6 months in jail and or a $2,000 fine on the other. You have worked out an agreement where they're offering you 27 days in jail for on one, 18 on the other, with credit for 9 and 6 respectively. Is this how you understand the agreement, sir? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Is this how you understand it? How do you plead to the offenses? Guilty or not guilty? I'm going to find you guilty, sentence you to 27 with credit for 9 on one, 18 credit for 6 on the other. Every time you go back to that house, same thing will happen. Every single time. Do you understand? Don't go back. Okay.